Now, IHL is, as I mentioned earlier, international human rights law is another legal framework that applies. So IHL is not the only legal framework that is useful to know about in conflict contexts. Another important and applicable framework that is drawn from international human rights law is the UN Guiding Principles on Business and Human Rights, the UNGPs. And these are really the global blueprint for dealing with human rights abuses connected to business activity. So these were adopted in 2011, and since then, companies have become much more aware that their operations and supply chains can generate significant human rights risks. So issues like forced labor, unsafe working conditions, discrimination, land rights violations, and many, many more. To deal with these issues, most companies now have some form of human rights due diligence framework in place. And they use this to identify how their activities may cause, contribute to, or be directly linked to negative human rights impacts. This type of due diligence expectation applies to conflict zones as well, but with a very crucial difference. So in conflict, the risk of abuse is much more severe, and the consequences of getting it wrong is much more serious. So the standard of due diligence is also higher. And the UN Working Group on Business and Human Rights has called this heightened human rights due diligence. There is some confusion around what the word heightened means in this sense. And it really means a different type of thinking altogether, not just more of the same. So when companies operate in conflict zones, the standard question is, what is our impact on people? But in conflict, that's not enough. They also need to ask, are we making the conflict worse just by being here? And in order to understand that, in order to answer that question, that means understanding who the armed actors are, how they relate to each other, what's driving the violence, how the company's day-to-day activities interact with all of those elements, and what harm might result. And not just to the individuals affected, but also to the conflict itself. But I would say that even this isn't the full picture. The development of this much more rigorous approach to due diligence in conflict settings certainly is a real step forward. I mean, it's a genuine recognition that operating in a conflict zone or in a volatile market is fundamentally different from operating in a stable market. But the critical gap that hasn't yet been properly addressed is that heightened human rights due diligence and IHL compliance are not the same thing, and one doesn't substitute for the other. So as it currently works in practice, heightened due diligence doesn't ask the questions that IHL actually requires. So it doesn't ask whether the company's activities are taking place in a legally recognized armed conflict. It doesn't ask whether the company's activities are closely connected to that conflict in a way that brings IHL into play, that triggers IHL. And it also doesn't ask whether those activities are contributing to violations of international law, including war crimes. And these are distinct and critical questions, and getting them wrong, as we saw, can have very serious consequences. So this is the gap that my own work specifically addresses. I call it IHL-informed due diligence, and it's designed to be a complementary methodology that sits alongside or within heightened human rights due diligence and asks those IHL-specific questions that heightened due diligence by design does not. So what I propose in my IHL-informed due diligence framework is really 3 sequential steps. The first step is conflict classification. So before anything else, a company needs to ask a threshold question. Does an armed conflict legally exist in the context where the company operates or where it has activities? As we discussed earlier, this is a legal determination. It can't be answered by consulting a political risk index or by relying on a government's characterization of the situation. It requires applying the criteria that are established under IHL for IAC and NIAC, as we discussed earlier. If no conflict exists in the legal sense, IHL simply does not apply, and the company's obligations are governed by international human rights law and managed in a heightened human rights due diligence framework. If armed conflict does exist, then the analysis moves to the next step. And that second step is a nexus analysis. So the company must ask whether its specific activities are sufficiently connected to the conflict in the sense I discussed earlier. So this analysis has to be granular. It needs to examine individual activities, products, services, relationships, because a company may simultaneously have activities that are connected to conflict and activities that are not. And each must be assessed separately and on an ongoing basis, because the relationship between a commercial entity and an armed conflict can shift as the conflict evolves. And then once that step is embarked upon, then the third step is a complicity assessment. So where a sufficient connection is identified, the company must go further and ask whether its activities generate IHL-specific legal risk. So in other words, whether those activities can be found to have had a substantial effect on the commission of a crime, and what the company knew or should have known about this before it acted, before it made the decision. Where serious exposure is identified, there are a number of options that a company can decide from. These range from implementing mitigation measures, restructuring the relevant commercial relationship, to, in more serious cases, exiting or withdrawing from the context altogether. And then importantly, none of these steps can happen in a vacuum. So IHL must be integrated into the company's risk management frameworks and across the organization much more holistically. It needs to be inserted into capacity building. It needs to be embedded into monitoring and communication processes, into stakeholder engagement, and perhaps most importantly, into governance processes, clarifying who in the organization is responsible for conducting the analysis, what expertise do they need or need access to, what is the escalation process, when exposure is identified, and how do these findings feed into senior leadership and board level decision making. And then I think without answers to these particular questions, even the best heightened human rights due diligence frameworks simply won't be able to translate action into better decisions. I guess in terms of what this means in practice, the companies and individuals that are now facing criminal proceedings in France and Sweden and elsewhere did not, for the most part, intend or set out to commit atrocities. They were fundamentally trying to keep operations running in very complex and challenging environments. They were trying to protect jobs and profit margins and contracts, to manage the competing pressures of shareholders and consumers and communities and governmental authorities. However, almost certainly they were doing this within a framework that simply failed to ask the right legal questions before those decisions were made. And this is what I would argue IHL informed due diligence is specifically designed to provide. Not a guarantee against liability. I don't think any framework can offer that, but a structured, legally grounded process for identifying exposure, understanding what it means, and then making informed decisions about what to do with that knowledge. I guess the question that IHL informed due diligence forces a company to confront is, given what we know or what we should know about this environment and our activities within it, what are we choosing to do? So perhaps I could close with where I began. I guess the assumption that international humanitarian law is someone else's legal problem, something for governments and armies and international tribunals and courts, is understandable, but it's increasingly indefensible. Armed conflict does not merely intensify the human rights risks that companies face. It triggers a very distinct, unique legal regime with distinct rules, distinct obligations and consequences, including criminal consequences for those who violate them. And a due diligence process that is calibrated to human rights risk, however sophisticated or rigorous, is not a substitute for a process that also asks the questions that IHL requires. What distinguishes a company that navigates these environments responsibly from one that ends up in a court is not usually a matter of intent. It's a matter of analytical rigor, governance discipline, the institutional capacity to ask hard questions and to act on those answers, even when the answers are commercially inconvenient. So I hope this session has been a useful introduction to what is, I think, one of the most important and underexplored intersections in international law today, and one where there is still serious work to be done. I think it's an area that across faculties and across sectors and industries, be it technology, law, engineering, political science, I think where we can all come together and have a really valid and real impact on the ground, not forgetting that the most important result of all of this is to ensure that there is an element of humanity that's preserved in the darkest of times, and that is in times of armed conflict. So thank you very much for having me. I'm very happy to be here and look forward to some questions.
Thank you very much, Ms. Favkornadi, for the great explanation about specifically about international humanitarian law. I know this is some kind of heavy topic for us to bring up into discussion, especially in webinars, yeah, because about international humanitarian law is not something like to be talked about. It is very good explanation to us too, because in semester 4 from business law study program, we also learn of international law, especially in international humanitarian law after our midterm semester. So this topic is something not really new, but something like a hot topic for us to be discussed about. So for our next session, after the main session that we already hear, we opened a Q&A session for our lovely students here to they can ask questions about international humanitarian law or maybe public or general international law. Also, its correlation with technology studies and also with business studies. So please, if you bagi teman-teman, please allow me to use Indonesia. Bagi teman-teman dari program studi, dari hukum bisnis, dari MBI, dari ada bistik di sini juga, ada dari IT, saya percaya juga ada. Silahkan apabila teman-teman memiliki pertanyaan terkait dengan international humanitarian law, atau kita dalam bahasa Indonesia sebut hukum humaniter ya. Teman-teman bisa untuk memberikan pertanyaan melalui kolom chat. You can use chat comment session untuk bisa bertanya. Please mention your name and also your study program first before you enter your question, or you can raise your hand, virtual raise hand in this Zoom meeting to let me know about your questions. Please proceed for our students. I do believe that they already have some distinguished question that we can share and we can discuss here, Ms. Val.
Wonderful.
We highly encourage an interactive and respectful academic discussion so that this session may become a meaningful and meaningful forum for exchanging perspective and idea, especially in also in humanitarian law and also for law of human rights. Because me as a lecturer also, I also list some of my questions and some topic that we can bring up here to be discussed. Maybe we can talk about it first before our students also bring up their question. Oh, we have Miss Veronica or Miss Icha, Mrs. Icha into this question and discussion session. Please proceed, Miss Icha.
Okay, thank you, Bu Lisa. Thank you for the insightful presentations, Ms. Hoff. I would like to ask, considering recent controversies involving multinational technology companies such as Amazon, Google, as examples of corporations providing code and AI infrastructure to state and military institutions. Do you think the current interpretations of substantial contributions and knowledge under the aiding and abetting doctrine is sufficiently precise to ensure meaningful corporate accountability for human rights violations and conflict affected areas? Thank you so much.
Thank you, Veronica. Excellent question. Thank you very much. And I think a really pertinent and topical one. I think perhaps the most obvious examples of that scenario that you presented at the moment is in the context of Israel and the occupied Palestinian territories. The report I mentioned earlier, the UN Special Rapporteur Francesca Albanese's report, talks in great detail about the role and responsibility of technology companies and the potential implications of legal implications of their contributions in the genocide in Gaza. Without having a legal advocacy background, so in the sense that I don't practice international criminal law, but I think just given the conversation that we've had today, you know, if you look at the sort of the two elements that I discussed, so the contribution element, so has the company contributed in a meaningfully material, substantial way to the end use, so to the ultimate perpetrator, the primary perpetrator's commission of the crime. I think in many respects, without going into the details of individual businesses, but I think in many respects that contribution can be made out. And then coming to the second element around knowledge, there are in certain conflicts and circumstances much more complicated investigations that need to happen in order to determine whether the company had knowledge of how their contribution was going to be used. I think in certain conflicts that aren't necessarily covered as well or as often by media, that don't necessarily have criminal investigation firms and officers doing that kind of evidence collection and investigation. I think in those sorts of situations, determining the knowledge element can be very difficult. I don't think that's the case for the situation in Gaza. So I think there are very few of us on this planet who don't understand what's happening in that part of the world. And I think all you have to do is read a news article to know that the contributions of many of these corporations, to know that if you are making that contribution, that there is an extremely high risk that it will be done in the context of human rights abuses or violations of international humanitarian law. So I would argue that it's highly unlikely that a board member or an executive or anyone involved in those technology companies, I would find it difficult to argue that they didn't have the knowledge that that was going to be used in a particular way. So I think you have identified a really important area of international criminal law that needs to, that I think will get a lot of coverage in coming months and years, not just in the technology industry, but in others. But yeah, certainly an excellent example.
Okay, thank you, Bu Icha, for the questions, and also Ms. Pov for the answer. Maybe I can also bring up my question because it is chained by Bu Icha's question about connection or legal relationship between a company and a war situation. In practice, it is not uncommon for a company to have like a shell or like a shadow company to conduct transactions. Also, the transaction is like a black transaction or enter into a legal relationship with what can we refer as perpetrators, or maybe we can say in a broader name like a Zionist. Yeah, it is also not uncommon for these shell companies or shadow companies to be based overseas. But the impact they have to many countries can be happen and can be felt towards or abroading nation. Since we are in business law, are currently discussing about humanitarian law, can you please enlighten to us the methods of evidence that can be employed by the relevant authorities?
Yeah, it's such a good question. I've been looking into this recently. I think, and I think the Lafarge, the French concrete company example I referred to is a good example of this, even though that case was specifically about enabling and financing terrorism and not contributions to war crimes, but I think it still addresses the same issue. So I think where international humanitarian law and international criminal law is very helpful in this sense is that it's not they don't tie themselves to corporate structures in the same way that, as you very well explained, parent companies, subsidiaries, non-majority owned joint ventures, these sorts of arrangements are set up in a very particular way, and in many cases they're done in that way for very specific domestic reasons. When it comes to international criminal law, again, as long as you can establish those two points, those two areas, the two elements, the contribution element, so the conduct element, and the knowledge element, then it's almost, there's a huge amount of evidence that has to go into, establishing the relationship and the sort of effective control that a company has over its subsidiary or otherwise. But it then is relatively straightforward in terms of, extending that legal liability to those other corporate entities. It doesn't have to be geographically in scope in terms of, the company doesn't have to be in the country where the conflict is taking place. In many cases, the country of the home country of the company is somewhere entirely different. As long as you can point to the contribution and the knowledge factor, not only in the perpetrator, maybe in the subsidiary company that's directly provided the contribution, but then also the parent company and then the board members of the parent company who might have had the knowledge that the subsidiary was passing that contribution on to the direct perpetrator. Those links are all very important. So I don't think that traditional corporate structures protect companies or their high-ranking officers from international criminal liability in the case of serious violations of international humanitarian law and other atrocities like genocide and crimes against humanity.
Thank you, Ms. Pfaff, for the answer to my question. It is also in my mind for a very long time too, because our world is not as it's not as clear as we imagine in the theory or in the book, especially in law, because in law we also learn about politics, and politics is not about a black and white or something yes or no, but it also have some gray area that we cannot face or we cannot touch if we don't have any like field background before. So it is honor to us, especially me, to be enter this discussion with you, to have a combine or a combination of what kind of theory we already have in our class, and also with your specialty in field. It is very wonderful experience that we have.
Thank you.
Can I ask one more questions? It is also related to your specialty and your experience in Red Cross. Maybe you can share to us what challenges have you faced in providing legal protection, for example, for the media and medical personnel in high-risk areas.
Medical personnel?
Yes, medical and media personnel in high-risk areas or in red areas, especially.
Yeah, sure. I mean, so medical, humanitarian workers, media, I think you said, journalists and the like. I mean, under international humanitarian law, these special categories of people are afforded very specific protections, whether they're in the Geneva Conventions and additional protocols or whether they're in customary international humanitarian law, so norms that have become binding. There are very specific protections that are extended to these categories of people. But what I think, as you already said, what the law and the theory provides can be extremely disparate from the realities, the practical realities on the ground. Certainly at the moment we're living through a period where those protections are not being upheld. The number of humanitarian workers and media personnel and journalists that have been attacked and killed in conflicts in the last 5 years, 10 years are greater than any numbers we've seen in wars past. I know that, I mean, this is a little outside of my area of expertise, and I haven't been with the Red Cross for a year or a bit over a year now, but there is some much deeper work that the broader International Red Cross Red Crescent movement is taking to look at strengthening those protections for humanitarian workers, in particular in conflict zones. It's a multilateral effort between states and Red Cross societies and other groups and humanitarian organizations and private sector and international organizations. So I know that there is a lot of work being done in the space, and I think, as I mentioned at the end of my presentation, all of these issues are going to take a multilateral approach. It's not just the role of civil society, it's not just the role of the Red Cross, it's not just up to governments or businesses or the humanitarian sector. It's going to take a huge effort from everybody to remember why we have humanitarian laws in conflict, and to stand behind that and believe in it and reinforce it. So I don't have an answer, I don't have a solution, but I think there are people, I know there are people sort of much smarter than I am who are working on these questions and working on these issues, and it's definitely an area that needs much more attention.
Wow, thank you for your sharing experience with us, because unfortunately, we in Indonesia has recently been rocked by news that several reporters from Tempo, from a certain news channel, has been captured by some armed figures. So we also want to explain and also want to have an explanation about these cases regarding in humanitarian law also, because in humanitarian law it is not really common in Indonesia to talk about humanitarian law actually. So if we have or faced some kind of a position like this, sometimes we as academics or early academics in university don't know how to respond about it. Some of us only respond with some sympathy and empathy, but we as also me and also our colleagues in business law also have to respond it with some legal perspective. And it is something that maybe we have to elevate more in our university also with our distinguished and lovely friends from other study program too, with managerial education, with their technology education, and also with their digital business education. I think the area of legal interpretation is highly needed by Indonesia right now to face this kind of situation. So maybe our discussion today can be some explanation that very good to us. Okay, so for our meeting, I would love to invite all of our distinguished students, our lovely students, to enter our discussion. Maybe one or two questions from our students. You can raise your hand. You can type. Oh, there are Adiatama Wirabuana from Business Law Study Program, and also Najwa Yori Nordianingrum for Business Law. We please welcome Adiatama to our discussion. You can speak up now. Adiatama. Hello, Adiatama. Are you there with us to enter or to deliver your questions regarding this topic? Okay, maybe Adiatama is on his way to type or to comprehend his word. So, Najwa Yori Nordianingrum, please deliver your questions to our session today.
Okay, thank you so much, Miss Lisa. First of all, I'm sorry, I can't open my camera because there are some technical issues with my device. So I would like to give a question and a little bit discuss with Mrs. Wolf. So I heard talk of a boycott before, and in my view, boycott have become a sort of a conventional trend among the public, especially in our country right now. On that, in a natural interpretation, unfortunately influence how the market perceive products branding. In Indonesia itself, the issues of boycott remains a subject of a debate, particularly regarding individual rights that are seen as conflicting with the collective human right to life, like the right not to be in a state of war like that. So how is this relevant to human rights that are potentially being violated by prohibiting people from purchasing certain goods suspect of being linked to the financing of war weapons? Thank you.
Okay, so I think if I understand your question, it is around the ability of consumers to be able to boycott products, and if the products are being used, or if it's a financial company, if the finances are being used to carry out violations. Did that sound right to you, Belisa?
Yeah, like how can people they are from purchasing, like they stop to purchase some kind of product from the big company, like how can it can link to the financing of war weapons?
Yeah, so I mean, I think boycotts and divestment campaigns are just one tranche, one lever that consumers and others can use in the kind of broader arguments against companies, against the actions of companies. So I think, consumer action such as that, shareholder pressures, media and civil society pressures, I think all of these combine to create a pressure to encourage companies to act in a certain way, or to withhold from acting in a particular way. I mean, there are certainly examples of those types of efforts gaining traction and having enough ground to be able to then encourage companies to divest. I think the Sovereign Wealth Fund in Norway is probably a good example of that level of divestment happening at pace, and at a really high level. And there've been a number of strategic divestments, particularly in the context of Israel and the occupied Palestinian territories, to choose not to finance certain industries or certain companies. For instance, the construction company Caterpillar, who have been called out for providing construction and demolition machinery in the West Bank. These types of actions, I think, coalesce to be able to provide those sorts of levels of pressure on companies, and it doesn't necessarily take just one of those. I think sometimes it needs a kind of groundswell of those, but it can certainly have that desired effect of encouraging companies to withdraw or exit from a context, or to divest from a particular company or industry.
Hello, Najwa. Did the answer from Ms. Wolf already satisfied your questions?
Yes, thank you so much, Ms. Phelps.
Thank you.
Lovely. Thank you, Ms. Phelps, for replying the beautiful questions handled by Najwa. I want to read our students' questions from the comment section by Adiatama Wirabuana. There's a this is an intriguing questions, especially regarding the relationship between international legal legitimacy, especially in legal scholarship. So he's asked how strong and effective is the binding force of international law in regulating and overseeing multinational corporations. After all, based on the examples mentioned earlier, there have been many violations. So he get the impression that it isn't very effective.
No, I think that's a fair question. Thank you very much. Yes, I think it's a fair question. I think that the same statement could be made across not just within the private sector, but also with governments. I mean, the level of impunity that we've seen, so the sort of lack of investigation and lack of prosecution into state authorities, individual perpetrators, businesses, I think that's been common among various countries, various industries, various conflicts for a number of years. I think that's changing. So I feel as if, particularly the corporate legal liability cases I mentioned earlier, and they were just a handful. There are more, but Lundin, Lafarge, BNP Paribas, Total. I mean, there are a number of an increasing number of examples of courts and other complaints bodies and regulators taking these allegations very seriously. In some ways, I think that there is perhaps more of an appetite, in some ways, I think it could even be slightly more straightforward to investigate and prosecute private entities than it is to prosecute, heads of state who are currently embroiled in serious atrocities and armed conflicts. And a number of jurisdictions are making this happen more and more. So, in Australia, for instance, we in our domestic criminal jurisdiction, we have the ability to prosecute companies as an entity in and of itself, and the individuals associated with that entity. But also in Europe, I mean, there's been a proliferation of war crimes investigations units that have been created within domestic criminal functions. And so, I mean, we're seeing that most obviously in France, I think Sweden and Germany, and in particular, Sweden and Germany are also following suit. But we're seeing these examples of those criminal allegations being taken much more seriously. So I acknowledge and recognize that there is a level of impunity that has and continues to exist when it comes to violations such as war crimes. But I do think that that is slowly changing, and that we will continue to see greater investigation and prosecution of private entities as we move forward.
All right. Thank you, Ms. Phelps, for the answer. Adiatama, do you have any follow-up questions regarding the reply of your questions? If it's enough, you can also tell us in the comment section, because maybe his mic or device also face a technical issue, so he cannot bring up the questions directly. So we are sorry for that. Another questions from our students, or maybe from our lecturers too? We have several lecturers too in here. We can also share and discussing things here. So please enjoy this discussion in academically and also in leisure gesture. You can share with us your questions regarding international humanitarian law.
I just want to ask a question from a layman's point of view, okay, from somebody who's not from this law perspective. So for those companies operating like in, for example, Middle East, like in Dubai, are they protected by international laws or not? Like those companies affected by war with their employees and everything? Yeah.
Yeah, thanks, Jacob. It's a good question. So I guess the first point to make is really looking at the context within which the company is operating. So if the country in question meets that threshold, the legal threshold of armed conflict, then yes, absolutely. And I mean, sorry, when I'm talking about international law in this respect, I'm just talking about international humanitarian law and therefore international criminal law. As I mentioned, international human rights law applies at all times in times of peace and conflict. And so arguably every individual in the world is covered by those laws within their own domestic jurisdictions. But in terms of international humanitarian law, it will always apply and with it provide protections and obligations if the country in question is in conflict. So in I think you mentioned the UAE, I think, when you in your example. So it's not part of a conflict. It's not, I mean, sorry, it's not classified as an armed conflict, and therefore international humanitarian law does not apply. But to the extent that businesses that, for example, might be headquartered there that contribute to armed conflicts that are taking place elsewhere in the world, then yes, those obligations and protections flow as well. So if you have UAE headquartered personnel that are providing, military material to a conflict in Yemen, for example, then there are obligations and indeed protections that flow with that relationship and with that context under international humanitarian law. Yeah. So some of it is geographically contextualized depending on where they're operating. And then other times that sufficient connection is established through the types of activities and the types of relationships that they're engaged in the day-to-day business. Does that answer your question?
Yeah. Thank you. Thank you for.
All right, thank you, Pak Jacob, to give us our final questions during our Q&A sessions. Thank you for all of the questions delivered. That is very interesting and important points that we can gather here. Thank you, Ms. Pfaff, for insightful explanation you have given to us. Distinguished guests, ladies and gentlemen, in conclusion, when it comes to legal proof and also legal protection under international humanitarian law, it is important for us to view companies as an active participants, as a subject rather than merely object affected by war or a conflict. As such, as future legal professionals and business practitioners, we must also view these issues through a proper lens so that legal certainty can be achieved in practice. To all students, please sign the attendance sheets provided in the comment sections later as we come to an end of today's webinar. On behalf of Universitas Sugeng Hartono, I would like to express our sincere gratitude to Ms. Pfaff Purnadi, LLM, for sharing her valuable knowledge, expertise, and perspective with us today. We would also like to thank all participants for your enthusiasm, thoughtful questions, and active participation throughout the sessions. We hope that today's discussion will inspire deeper awareness in continued dialogue regarding the relationship between international humanitarian law, human rights, responsible business practices also, and the stability of international trade in times of global uncertainty. Before we close our session this day, we want to take a picture of you. So the students with the closed camera, can you open your camera for a second so we can gather your picture in one screenshots or a few screenshots? Teman-teman, silahkan untuk membuka kameranya. Bagi teman-teman panitia atau penyelenggara, bolehkah membantu saya? Can you all help me from the event organizer to capture our lovely participants here. Bagi teman-teman yang belum on cam, please open your cam first for like 5 seconds so we can documentate in a good way. Mari teman-teman, kameranya silakan dibuka supaya kita bisa mendokumentasikan kegiatan ini dengan baik. May I ask Pak Adi for conducting us in our photo group session?
Okay. Yeah. Please give the best your smile. Okay. 1, 2, 3. Smile. Yeah. Again. Maybe freestyle. Yeah. Okay. Yeah. Sorry. Technical issue. Yeah. Ready? Okay. 1, 2, 3. Okay. Yes.
You are still muted, Bulisa. You are still muted.
Thank you very much, Pak Adi, for lend a hand to screenshotting our discussion today. Again, thank you very much for all participants that give your excitement towards this international webinar. We hope that this international webinar issued by Universitas Sugeng Hartono can be continued and sustained in a good way in different topics. Maybe you can share your suggestion too about your topic for our next international webinar. Thank you very much, Ms. Fav Kurnadi, for your time, for your insightful explanation to us. It is very honored to us to have you here. So we can also practice it in the future in a good manner. So my name is Maranatha Lisa, and it has been a pleasure serving you all as your moderator today. Thank you once again. Stay safe, stay healthy, and we look forward to seeing you in our future academic forums. Have a wonderful day, guys.
Thank you for having me. Thanks, everyone.
Thank you so much.
Thank you,
Thank you
Miss
so
Fav.
much.
Thank you so
Thank
much.
you.
Thank you so much.
Terima kasih banyak untuk teman-teman yang sudah menghadiri international webinar ini. Saya harap dari penjelasan yang diberikan oleh Ms. Fav juga bisa memberikan pemahaman bagi kita tentang pentingnya international humanitarian law atau hukum humaniter. Bagi teman-teman yang belum mengisi lembar presensi atau form presensi, dimohon segera untuk mengisi supaya dapat diisikan sebagai salah satu bukti keikutsertaan teman-teman, terutama bagi teman-teman yang ada di hukum bisnis. Presensi ini juga menjadi untuk teman-teman semester 4, presensi ini juga menjadi presensi kehadiran untuk pertemuan 9 dari hukum internasional dalam pengajaran yang saya lakukan. Terima kasih banyak semuanya. Sampai jumpa di kesempatan yang lebih baik lagi.